business. The only item under new business is the discussion of the City of Urbana use of criminal background checks, and that'll be led by Carol Mitten. And I believe we have some representatives from the Human Relations Commission, and Elizabeth Hannan will also be participating as well.
Elizabeth and I are going to run through some slides to begin with, and Elizabeth will start, and then we can take questions or have a discussion after we go through the slides.
Okay. I'm just going to share my screen here. All right. You should be seeing that, so if not, let me know. So before we launch into this, I do want to advise you that I'm one of the respondents in some of the pending matters that have come to the HRC related to the background check requirement. So as Carol said, we're going to tag team. I'm going to talk about some of our current practices, but I'm not going to discuss any specifics about the complaints. So our human rights ordinance has for many years allowed background checks to be used as long as they're used in a non-discriminatory manner. This applies to all employers in Urbana, not just the city. And some of the relevant ordinance language is in section 1237 of the code. Conviction record is added as a protected class. In section 1262C, it specifies that it's unlawful for an employer to inquire about protected status for a reason that's based wholly or partially on discrimination. In section 1262F2, it says it's not unlawful to advertise a limitation if it's a bona fide occupational qualification. And in section 12105A, it talks about any practice that would otherwise be discriminatory is not unlawful if it's justified as a business necessity. So back in 2013, and I think Fran actually circulated a document to you. There were some guidelines developed that the human relations officer at the time used to provide guidance to all employers in Urbana about how to implement this requirement. So those weren't formally approved by the HRC, but they were reviewed because they were just guidelines for the HRO. So those rules included the following: that employers may not inquire about conviction status on employment applications, that employers may provide accurate information regarding several things, including the fact that upon extension of a conditional offer, the employer intends to run a criminal background check. And it also lists a number of factors that an employer would have to assess before they would deny employment based on a business necessity. So some of those factors, and there's a longer list, but are, considering the facts or circumstances surrounding the offense, the number of offenses, the applicant's age at the time of conviction or release from prison, any evidence that the individual performed the same type of work post-conviction with no known incidents of criminal conduct, the length and consistency of employment history, rehabilitation efforts, and there are several other items mentioned that should be weighed. So now I want to turn to our practices at the city, which we believe are fully compliant with that guidance. So, and I just to be clear, I'm setting aside positions like police officer where there are specific requirements in the law. But we require background checks when there's a statutory requirement, police officer would be an example of that, or a significant nexus with the essential functions of the job. Applicants are not asked about prior conviction on job applications. Background checks are conducted only after we make a contingent offer of employment and that contingent offer is accepted. And applicants are notified of any findings that might result in a denial of a final offer of employment, and they're given an opportunity to explain before we would make a final decision. I want to point out that I also reviewed these practices with the HRO who drafted the guidelines, and he agreed that he felt that we were in compliance. So at this point, I'm going to turn it over to Carol to talk to some specifics about one of the items.
So this initial complaint that I'm going to speak about is the one that you've heard us talk about that led to, me bringing forward the change about jurisdiction of the HRC. So the initial complaint is the one that had the informal hearing about jurisdiction and probable cause on November 10th, 2020. So I just want to add in this a little bit more detail because you've heard a lot about people, I think, extrapolating things from this complaint, but I want you to know exactly what it says. So the complaint states in part, the Urbana Civil Service Commission held a public meeting wherein they discriminated and conspired with city staff to further discriminate against individuals on the basis of an applicant's prior arrest or conviction record. And the complaint goes on to indicate that the named individuals did this by, quote, creating, voting for, and disseminating a job listing, which includes the requirement to pass a criminal background check. So the jobs in question were job descriptions for a human resources assistant and human resources coordinator. Those position descriptions indicated that a background check would be required. And individuals in human resources typically have access to personal information, including social security numbers and all manner of employees' personal information. So next slide. So just so that everyone is on the same page about this, a job description is a document that describes the duties, responsibilities, essential functions, and necessary skills, experience, and qualifications for a specific position. So we include in this requirement in job postings so that applicants are aware of the requirement. They need to be aware of the requirement. We do not want applicants to be surprised by that requirement after they are far along in the process. Next slide, please. So one of the things that we did as a result of the November 10th hearing, and I had communicated this to the HRC in a memo, and I shared that with every council member as well, is that we made certain changes to the job ad and our job ads that require background checks, which is not all of them. They now include language saying that information obtained in background checks is considered in the context of the nature of the job, the nature of the offense, and the time that has passed since the offense, and an arrest or criminal conviction does not automatically exclude an applicant from consideration. So we have the job description itself, which states whether or not a particular job is subject to a background check. Then in the ads that are associated with those particular position descriptions, we explain to people how we apply that. And then finally, so the conclusions that we would like to draw your attention to is that this discussion has an implication for every employer in Urbana. It's not limited to the city of Urbana as an employer. And Elizabeth explained to you the document that the former HRO had shared with the Human Relations Commission. And that is how we educated employers about how to implement this particular aspect of the Human Rights Ordinance. Any interpretation of the ordinance that makes criminal background checks de facto prohibited ignores the business necessity exception. And then finally, explaining in the job advertisement how the background check is used promotes transparency and fairness because applicants know what to expect. And also including it in the job description itself, they know going in whether or not they know whether there will be a criminal background check, and the advertisement tells them how we will go about doing that. So we think that that's fair, that's transparent, and that's consistent with the ordinance. And Elizabeth and I are happy to take questions. And I know that at least I saw Francis with us, and yeah, and Pete too. Okay. So I guess the mayor will call on folks.
Any questions for Elizabeth, Carol, Pete, or Fran? Bill, and then Jared.
I wonder if you could expand a little bit on the business necessity exceptions. It seems like a lot could fall under that category, but then you also said that had to relate to the nexus of the position. Could you repeat that or rephrase it to make it a little bit clearer about when something is considered a business necessity exception?
Okay.
Seems to.
I think, okay, let me. Feel free to jump in here and help me out, Elizabeth, with the nexus piece. But I mean, I think we can give you some examples, and that might be the best way to do it. So for instance, what I tried to explain with these two positions in question about in the human relations office, if you have access to people's personal information, if you have a history of a crime, a conviction of a crime that involved, let's say, stealing someone's identity. So there would be a nexus between having access to someone's social security number and the crime that you had been convicted of. In some of the financial positions that we have, people handle money, or that they have access to financial information that they could misuse. So if they had been convicted of a crime that involved any kind of financial crime or fraud, then that would be a nexus. So it's not just anything. And as Elizabeth tried to point out, it also has to do with how long ago it happened, whether or not the person was rehabilitated, and so forth. So it's not even when we find that there's a nexus and there happen to be some crime, some conviction in the background, that's not necessarily disqualifying either. That then generates a conversation. Is that responsive to your question?
I think that helps. Does this apply to any conviction or only felony convictions? I mean, it seems like at some level, and we know that with disparity and everything, at some level, say shoplifting or something, people are going to be more likely to get caught because of their race or because of various reasons, and other people who may have the same behavior don't get caught. So I think it's these kind of minor infractions that we want to be a little bit careful about, or be very careful about using to deny somebody a job. So is there a, do they have to be felonies? Let me start back with that again.
I think Fran wanted to jump in here.
Yeah, I really would, and I'm sure Pete would too. I'm really glad to hear, Carol and Elizabeth, that you've been said a little bit more about in the job listing about what that background check, how it might be used. But I think you haven't gone near far enough if you're going to list that as something that is the first thing the person sees when they're going to apply for the job. Because very few probably of the people with criminal convictions or prior convictions or arrests are going to have the specific thing that you're concerned about. So it would be very helpful and not have the chilling effect that ban the box was enacted to get rid of if you were much more detailed about what you were looking for and what you were concerned about and how you were going to handle that information. Because if you don't get more specific about it, it's like putting something in the job description that says there will be a religious test, or you have to be of a certain gender or something like that. You owe it to these people. Yes, maybe you don't want to surprise them, although that's another issue. But you also don't want to scare them off, and you don't want to you want to be specific because you don't want to kill a mosquito with a machine gun here.
So can I just say
yes,
something?
please.
And I just want to, as we go through this conversation, I'm happy to have as full a conversation as people want to have. I just want people to understand there's a continuum here, and there's some kind of idealized mechanism, and different people have their sense of what's the ideal. And some people on this Zoom that I'm looking at think the ideal is to say nothing about the practice and then only do it if it's, and then it only becomes known if at that point of a conditional offer. I don't happen to be in that camp, but everybody's got this idealized version. And then there's gradations of, well, this could be better, that could be better, that could be better. But then we cross a line at some point and we have discrimination. And so we can have all the conversation you want to have here, but I think we need to be really clear. Just because we disagree doesn't mean that we're all either on the discrimination side of the line or on the non-discrimination side of the line. There's different ways, because we're accommodating a group of people that there is this gray area in our law that it's not black and white. That's what I mean by the gray area. I don't necessarily mean that it's ambiguous, but it doesn't necessarily mean that it's discriminatory if we don't do everything everyone idealizes that we should. So, and there are members of the public who would say that if we don't do this idealized version, that we are discriminating and that we are breaking our own laws. And I just simply don't agree with that. So I just want to frame the conversation that way.
I agree with you. And, but what I'm saying here is that this is not occurring in a vacuum. There's a history here about how jobs discriminate against people with this kind of thing in their record. And when you put in a advertisement for a job, a very general statement about a criminal background check, or you must pass a criminal background check, and pretty much it stays at that level of generality, that is going to, people know that they are going to continue to be punished for something that they were arrested for, possibly not even convicted or convicted of. And chances are, given the mass incarceration that we've experienced in our country and the bases of a lot of those convictions, chances are that a lot of people who will be intimidated by that will not have anything, it will not have any nexus, and yet they will be intimidated and turn away. And that is why you may not have it on the application, but if you have it on the job description, it's very similar in its effect, in its chilling effect. I'd also like to say that the rules that we're talking about that Todd Rent wrote were approved by the HRC, and they were approved by the mayor. These are not unofficial, these are real. I just wanted to add that. So when you put it in an advertisement, you are advertising it, I think that the way it's being done, while improved, is still a problem. And I'm not saying I'm not saying don't ever do a criminal background check. But I don't think it's so bad if you has been given a conditional offer. I don't think you're going to shock anyone by telling them now, because of the nature of this work, they're going to have to look and see if you have a certain kind of thing in your record. That's a very different thing from putting it on the advertisement in general terms. I'm very concerned about that.
I've been thinking.
I'm going to
Oh,
let,
sorry. You're
I'm
right.
going to let Elizabeth weigh in. She had her hand
Sure.
up before.
I just also wanted to, as a point of clarification, I want to make sure we're clear that the job description is different than the job ad, right? And so I feel strongly that if we don't include that as a requirement in the job description, and then we apply it later at some point in the process, that can kind of be applied arbitrarily.
I'm sorry, I thought it was I thought those job descriptions were circulated.
Well, they are. The job description is the place where we define the duties and responsibilities, the essential functions and the requirements for the job. But
Does the potential applicant see that?
they can if they look, yes.
There you go.
But the issue is
Yeah.
if we don't make it clear in the job description whether that's required, or in most cases not required, somebody can just then it becomes arbitrary. There has to be a place where we say
Right.
required.
But it can be much more specific. It can talk about the nexus right there, so that someone who was busted for marijuana is not going to worry about it and shouldn't worry about it. Because the fact that you have a prior conviction is not in itself a necessary or sufficient indicator of moral rectitude or suitability for a job. And that's the position of the HRC. Yeah.
So I wanted to start by giving a more direct answer to Bill about this. The short answer is it is not limited to felony. The ordinance is any arrest or conviction. What the exception does is give you a defense, right? You have violated the ordinance unless these things happen. So I could, do a background check only on felony convictions for murder, right? And the person can still bring a complaint and say they advertised that they were doing a background check. They did the background check, and then they went and didn't give me the job. And I could still bring the complaint, and the city could say, or any employer could say, I only checked to see if they were convicted of murder. And the commission might still find that there was somehow some sort of discrimination going on. This is, and if you read through the entire set of, and these are not rules per se, right? I mean, it is a rule in the general sense, but this is the things that you can do as an employer to make sure that you stay within the bounds and guidelines for staying within those bounds. So if you're going to do a background check and you're going to advertise it and you're going to use it as some part of your decision, you better do it in this order and say it in this way in order to avoid it being discriminatory. These were not uncontroversial when they were discussed at the HRC. And when we voted to say that we would basically say that these were okay. You are doing things that are not strictly allowed by the ordinance, but if you do it in this way, you're likely to not run afoul of it. And so whatever whatever the commission might find for a particular case, whatever the city might put in a particular job app or job description, one thing, and I'm trying to be limited in how I say this because if a case were to come up in front of the commission, I don't want to corner what we might find. But if you say that it is a requirement of the job to pass a background check, you're running pretty close to the edge, because you're not saying we might do a background check and then we'll have a conversation after we have made a preliminary offer. You're saying you must pass this check, which doesn't describe how it will be used. It doesn't say we're doing the background check, but we're going to follow up with you about this. It says you must pass it. And it's an interesting way to put things that seems tricky. So I hope that answers your question. It's not a solid defense to say we're reviewing all these things. You may have reviewed them, and the commission might come to the conclusion that, yeah, well, but you didn't review them in a way that we think is non-discriminatory.
Carol?
So a lot of, I've been involved in numerous conversations on this topic, and so some of these things I've heard them before, and one of the things that, like in Pete's, and Pete's very thoughtful person, he knows that I only we're just having a conversation, but once you start to construe this could happen. Of course it could happen. Something could go, it could get misused, but that's when there's a legitimate case of discrimination. Not like, I could imagine how you could do that, how you could say this and then misuse it down the road. Of course. But it's at that point when someone should bring the claim of discrimination, when something has happened to an actual person with actual details and circumstances. Not this sort of like, oh, I could see how the city of Urbana could just run amok with this. That's not discrimination. You might say, well, we'd like to narrow the guardrails, but that's not discrimination. So I just want to clarify that.
Any other questions for the commission? I think Jared, oh, I'm sorry. Go.
Just on the, I would agree that's not discrimination. I think it's a matter of, there's a difference between discrimination and how we want to implement our potential background checks when we need to. And I think that's the area that I would be concerned about. And I think you've addressed that with the advertising and I think was it in the ad or in the job description where it explicitly said that, I forget the word in a criminal conviction won't be.
You must pass a criminal background check is the wording.
No, the wording in the ad, Bill, I think what you're thinking of is an arrest or criminal conviction does not automatically exclude an applicant from consideration.
I think that helps a lot. And that's in the ad, right?
Yes.
Okay. Thanks.
Jared, you had your hand up.
So, I mean, I've got a number of things, and one thing maybe Pete can weigh in on this, or I see our new city attorney Dave is here too, and maybe he has something to offer on this too. But I still can't swear how putting it in a job description or having it in an application doesn't run afoul of the Illinois state statute, the Job Opportunities for Qualified Applicants Act, where, literally the language pretty, plainly states to me that you can't ask or mention or even talk about a criminal background check until certain things have been, a process has been reached, such as an interview has been offered or a conditional offer of employment has been made. I mean, the language seems pretty clear with that act. And so I still am struggling to even see why this is a discussion that we're we're even doing this when that language exists. So that's my first question I'd like to get some clarification on.
Kate?
So I think your argument is equally valid for our ordinance. 1262 E2 in relevant part. It is unlawful to print or publish or cause to be printed or publish any notice or advertisement or use any publication form relating to employment by such an employer or to membership or classification or referral by employment or labor organization or employment agency indicating any preference, limitation, specification, or distinction based on discrimination, right? And in order to get by that, you would have to show that that discrimination and remember the exception is where it's a bona fide occupational qualification necessary for employment. Or hire, and then there's the thing about hiring. But the notice or advertisement can't do it unless it's a bona fide occupational qualification, which means you're going to have to defend what precisely you're looking for in that background check that is a bona fide qualification. Now, the fact that we put out this rule, and I say we, the fact that the HRO at the time put out this rule was we were fully aware that people were doing background checks. We were fully aware that even if we told them not to, they could do it in secret and no one would know any the better. But it was the notice part that was the key thing. And if you're going to put it in the notice, you better show the bona fide qualification. The place where I disagree with what Carol said was it's not the mere act of discriminating in the job, in granting the job that's at issue here. It's the advertisement itself. The advertisement itself, by doing that indicates that you might discriminate, is enough to break the ordinance.
But I think that's the thing, Pete, is you say you're advertising that you might discriminate. It's like, no, we're advertising that we're going to use our bona fide, our authority that's granted for bona fide occupational requirements. You're assuming that by saying it, we're going to discriminate. And I'm saying you can only have that be true with a specific individual and a specific set of circumstances.
But again, the law is, the ordinance is that you can't indicate any preference, limitation, specification, or distinction based on one of those categories. You said we're going to have a criminal background check. Now you're going to have to show that the thing that you are searching for is a bona fide occupational qualification, which means to me that should you put that advertisement in, someone can instantly make the complaint before they've been denied any job offer, before they've been, even applied for the job. They can say the notice is discriminatory, at which point you would have to, as the city or any employer, would have to prove that it is in fact a bona fide qualification. And even if I was convicted of identity theft, I'm going to say there's a whole list of things that I could have done. You're going to have to show me not just that there's this list of things, but that you actually, it's this list of things that I have done that would violate, that would make it a bona fide occupational qualification. I think the burden of proof is being switched is all I'm saying.
I see Dave popped in. Maybe the mayor could call on him.
Would the city attorney have something to say about this?
Thanks. That's part of the reason I kind of popped in my video on, thanks to Councilmember Miller too for suggesting perhaps at least a couple of comments for me, and apologize for the glare off my glasses in this room. But I guess first, because I think this will kind of tail into the piece of the discussion that Pete kind of commented on, is that people ask me, well, can I be sued for this, right? As a generalization, can I be sued for this? The answer is always yes, regardless of whether the complaint is valid or not. Okay. And so so my take on the idea of the HRO, the ordinance on the provision, I apologize. I thought I had the ordinance in my file here to kind of refer specifically to it, but I apologize, I don't. But so if I misspeak, certainly I think Administrator Mitten or Pete or Fran, you can kind of comment if I'm off track a little bit. But in the ordinance, it says it's not discrimination if you use it in this fashion. So in a sense, I don't necessarily see it as a complete just exception or defense. It literally says it's not discrimination, and meaning that the complaint could not be filed at the very outset. Now, having said that, the complaint could be filed regardless, right? And so Pete, you're not wrong in considering the idea is that the city would then have to defend it. But I think that's where I see, maybe, and I don't mean this word to sound bad, and if it's the wrong word to use, I apologize, is a little bit of a disconnect on the idea of the thought about how this can work relative to the ordinance and potentially the statute. Again, I apologize, I don't have the statute in my file either to try and refer specifically to it. But I think that's kind of how we're trying to address the balance here of the idea. I think we all understand that if there are BFOQs, bona fide occupational qualifications, that relate to the idea of potential convictions, we all understand that that's possible, and they can be used, I think, in terms of the decision making on whether to hire someone or not for a particular position. And so I think it comes down to, as I think Administrator Mitten was commenting early on, is, how do we develop it to the point where maybe not everybody is exactly happy, but people always understand it and are okay with how this process is going to look going forward in terms of, the job description itself, any advertisement for that particular job, and then ultimately also, as Administrator Mitten described, and as Ms. Hannan described as well, is the actual logistical process when you're looking at them and have the possibility for the person to come in and offer an explanation of how, that this shouldn't necessarily be counted against them for A, B, and C, on that. And so, that's kind of how I see it at the moment, I suppose, is that, we recognize the idea of trying to reach the balance here. And I think the ultimate idea is how do we kind of get there to be consistent going forward and understand that, people see it as, we're not trying to discriminate. We're not trying to violate the ordinance in and of itself for these kinds of things. We're merely trying to be transparent and have people understand, at the very, in my mind, again, at the kind of the beginning, relative to this, because what I find invariably is that a lot of times when people end up wanting to file suit or a complaint is they're upset. I mean, they're mad. And so, the question becomes is, are they going to be madder up front? And I get the idea is that you're maybe dissuading people from applying because of the way of how that maybe is worded in the sense to try and help alleviate that concern at the beginning. But if, I see the side of it too, where if you wait until the very last possible moment before you say, yes, you're hired, and say, oh, by the way, we need to do a background to make sure that there's no convictions that really relate to the nature of this job. I could see people being more upset at that very point because now they are going to feel that they wasted all of their time hoping on this job, and all of a sudden now something happens where they're concerned. And again, I'm not saying this happens every time. Obviously, we're going to run into maybe one or two applicants that maybe fall in this category. I wouldn't want to suggest that it's 98% of the people applying will end up in this kind of capacity or on this particular path. But I see the concept of how do we allow people to understand that this is going to be a part of the process, and when do we let them know that, at the beginning or at the end?
I do want to just emphasize here as we sort of, I feel like people are wanting, I want Urbana to do something different, but whatever standard you feel that you have to hold the city to in terms of like really parsing this out, that becomes the standard that everyone is held to in Urbana. And that is, I'm telling you right now, that is not what we have promulgated to our employers. So there's, just know this is not just a conversation about the city of Urbana or, as a government. This is about all employers in the city.
Okay.
Yes.
Jared, you had other questions?
I just want a quick follow up with Dave. So I know you don't have the statute in, maybe we, I don't know, need to dive a little further into it, but, I just, it's like what Pete said, and I do get that we're kind of, now we're finagling with this idea of, well, should we ask later? Should we be upfront about it? And if we, at whatever point we disclose it, how do we disclose it? I think all of those are extremely important, but I also think that the conversation of upfront or later would be moot if the Job Opportunities for Qualified Applicants Act supersedes this, even asking the question about doing it at the front or at the back, because it seems to me like it says that you can't, you may not inquire about or into, consider, or require disclosure of criminal record or criminal history of the applicant until determined blah, 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 for an interview, or if there's not an interview until a conditional offer. I mean, that seems pretty straightforward to me. That's more like well, you just don't do it on the face. You have to do it on the back end. I just want to hear your thought on that specific part, Dave.
Yeah, it's one of those things where I really do wish I had the kind of statute in front of me. And again, not that this necessarily is the driver for it, but one of the things I try and look for when there may be a little bit of a difference between a statute and a city ordinance is whether or not the statute preempts home rule authority to act in that particular area. If it does, and it says you can't do anything that's inconsistent with a statute, obviously that's absolutely clear. And if a statute doesn't, then it somewhat is a question mark a little bit. And I'm not saying that you wouldn't want to take the statute into consideration regardless, but it wouldn't necessarily, put a city in a position where it couldn't do something that they felt was more appropriate than what the statute maybe provides. And so certainly understand the nature of the statute, certainly understand the nature of the conversation about, the concept of trying to ensure that people who might have a good background for the position aren't dissuaded from applying by the suggestion of having to do this as part of the process. But that's where I figure it gets one of those things where I think it's almost like a melding of a lot of things to try and reach a position that everybody's comfortable with going forward on how do we want to put these kinds of things out there. Because certainly, as I shared internally, there's a big difference between hiring a laborer and hiring someone in the finance department who's going to be handling money. And so I can certainly understand the nature of the conversation about, the idea of specificity, but I think, part of to look at how to do this is, ultimately is Administrator Mitten suggested is how far do you end up going on that? It's similar to creating a list. Once you create a list, you're stuck with the list, good or bad. And then people will say, well, you should have added this piece to that and taken this one out. So, when you create the idea of the language that you may use for this is, again, it's going to be, somewhat people's thoughts on, well, I wish it would have been worded this way, or I wish it would have been worded that way. And so, we just need to be comfortable with the ideas, how we want to establish this without putting people off, I guess, either way.
Carol, and then we'll move on to other council members who may have questions.
I do just want to slow down the reading of the act and what it says. So I'm just going to slow walk it, what Jared had said. An employer or employment agency may not inquire about or into, consider, or require disclosure of the criminal record or criminal history of an applicant until the applicant has been determined qualified for the position and notified that the applicant has been selected for an interview, blah, 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 blah. It doesn't say you can't notify them of the requirement. It says you can't ask them about, consider, or require disclosure. And we violate none of that. So I think that that you have to look at precisely what it is saying and then put that up against what we do. And I think we're in bounds of what the act says.
I don't know if I agree with that. I mean,
Well, did I just read the word? What part don't you agree with? What the words are? No, seriously.
No, I'm looking at it. No, you read it exactly as
Okay.
it's written. No, I'm just disagreeing with your interpretation, not about what's written in it. The specific part is require disclosure of, right? Require disclosure of. Now, when, for example, this was going to be my next point, and I'm sorry, to other council members that I'm taking up so much, because I'm sure other people have questions too. I appreciate the chairs letting me continue before I come back. But that part is the big part. In I don't know if everybody else looked at what Christopher Hansen had sent to us about as he went through a job application on the website, but there's almost 3 places where the criminal background check is mentioned, and in fact, it won't even let you submit the application on the website unless you have the consent to disclose your criminal background check checkbox checked. So you literally can't even finish the application unless you consent to the criminal background check. Like
that was a Urbana Free Library application process. I would just note it wasn't a City of Urbana process.
Well, in either case, I think the principle still of that wording, or required disclosure of, is where it comes into conflict. To me, that's a clear conflict of asking or requiring someone to pass a criminal background check in an application. That's where I'm reading that, and I'll quit belaboring that point, but and hear what other folks have to say.
Okay, let's move on to other council members who had questions. Mary Alice.
So mine isn't necessarily a question. I think one of the things that we're struggling with right now is the delineation between the practice of how background checks are used and how background checks are reported in the job description or the advertisement. So there's 2 things there. One, there's the process, kind of the HR process, right? And the other one is the paperwork that we have. If I was to write the rules, this is what I would say. I would say that the City of Urbana should not include any information about conducting background checks in the advertisement. And the reason is because it's very complicated. All the stuff that we've been talking about tonight is all these different rules in terms of, well, how would it be used? And it's not possible to actually go into that much detail into an advertisement. So why make people worried about it? Then in the job description, which is kind of the, what's on file at the city, you have more time there to describe if it is an occupational, if it is a bona fide occupational qualification for that specific position. You can put in the job actual description that says, this is a position that requires access to personal information and is considered a bona fide occupational qualification for you to pass certain kinds of background checks, so to speak. I'm not the wordsmith here, but my point here is that I think that we would satisfy the idea that we don't want people to get the assumption that we're going to discriminate based on these different items that we've said in the HRC. If we don't include that in the job app, we can go into more detail in the job description, and then we can talk about the whole process other side. So I'd really like to keep, if possible, this conversation around the job advertisement and the job description, because the whole other thing is long. So those are my comments.
Fran, did you want to say something? I saw you waving out of the corner of my eye. So
I was waving frantically. Yeah. I just want to say that 2 things. One, that it's very important, I think, for the people in the city who are advertising and hiring people to bear in mind what you are actually looking for. And what you are actually looking for is not someone without a conviction or arrest, or even someone who committed fraud sometime in the past. Or someone who has no such record. What you are looking for is an honest person. And if that is the quality you're looking for, that's the quality you should stress. And I completely agree with Mary Alice's statement that the mentioning of criminal background has no place in an advertisement. But you can talk about honesty and a proven record of honesty, things like that. You can look for character, but don't base it on something as problematic as a conviction, unless you really think it applies in this case much later on in the process. So that's one thing. And the other thing is, I would be very interested to know what, in fact, the city is promulgating to its employers, because I thought it was promulgating the ordinance. And if anything, these guidelines that Todd Rent developed. And if the library, the blessed library, is doing something that makes it hard for someone to even apply without giving permission to have their background checked, I don't mean letters of reference, I'm talking about criminal background, then something has gone wrong in Urbana.
So, oh, go ahead. Maybe
That's all.
I'll let the mayor call it. I keep
Sure.
jumping.
Was it Elizabeth?
Yeah.
Well, I was just gonna say, to be fair, I don't think Celeste is on here right now, but there may be special requirements in the law pertaining to library employees because they often work with children, much like employees in schools.
Okay.
I don't know
They
that.
should say that though.
I believe that is true. So I just need to stick up for them a little bit.
Yes, that's fine. And I want to say that let's not get too hung up on the particular complaints that have come in, because they are really no longer operative. And what we are going to be dealing with going forward is reports of concerns that the HRC is going to try to, by diplomatic means, correct in the city. And no, we don't have a process for it yet, Ms. Chong, but we will, and it will be specific and it will work, hopefully, and it will get improved over time. So I'd just like to add that. What happened in these complaints isn't really relevant.
I will add, I did ask about the library position. It was specifically for the IT position, and that person has access to everything. So
that isn't, whoops.
Yeah.
That doesn't mean it's required by a state or federal law that there be no criminal background.
no, but anyway, that's what the position was for. Who was next? Dennis.
I really appreciate Mary Alice's take on it, that we shouldn't be discouraging people at the application process from seeking employment at no matter what level. Just as we don't specify specifically what kind of background experience that they have to have when they apply, but we discuss it during the interviews, and we then look for details about what kind of what is the depth of their experience to fulfill, say, a managerial position or an organizational position. And we should have the same attitude about accepting and being open to applications from a wide variety of individuals. And then if their position happens to have a very particular sensitivity, we can go into that discussion during the interview process, or if it's requiring character references to support the application, one can say, well, we're looking for a certain kind of character reference, a certain kind of individual proof of individual qualities. And we can get into those things then, but I would certainly not start laying those kinds of expectations down at the very application process. And you know that a lot of people apply for jobs that they're not really qualified for, but they're having the experience of having interviews, or they're just trying to get a job. And they're being, we shouldn't be discouraging people with the highest level of discernment at the very beginning of the process. That comes later.
Any other council members wanting to weigh in? Eric?
So perhaps another way of navigating this is to have on the Human Resources website for the city, its policy and the laws and ordinances that underlie that policy. It's going to be analogous to, for example, what the University of Illinois Human Resources does, where it does specifically say that anyone accepting an offer of employment will have a criminal background check done. So at some point, you have to be honest and say what the policy is clearly. Otherwise, you're saying you want an honest person as an employee, but if you're not going to tell them what the process is up front, that's not very honest either. So we have to have a clear policy that is communicated to the public, including job applicants.
Any response? Carol, and then Bill Brown, had your hand up.
Well, I just want people to be clear about what we have told employers. And this is explicitly what we've told employers, okay? That's what's in these rules. And for anybody that has it, it's on page 18 under, it's 4E. And it's under a heading, application of law to covered employers. And then it says, the following rules shall apply to all covered employers, A, B, C, D, E. Covered employers may, at any time, provide to applicants or potential applicants accurate information regarding the following. Number 1, the duties and responsibilities of the applied for positions, and 2, whether upon extension of a conditional offer, the employer intends to run a criminal background check on the applicant. That's at any time. That means including the advertisement. So again, this is not just about the City of Urbana government as an employer. This is about everybody that we have gone out and tried to explain our ordinance. And as Fran and Pete both said, the HRC approved these rules, and that's explicitly what it says. So we can change that if that's what people desire, but that's not what we said.
Bill Brown.
Yeah, I think the HRC is well qualified to figure out the details about whether the Urbana or other employers are meeting the ordinance. But I think as a city, we can go a step above if we feel that, by putting the language past a criminal background check in an ad, I think it does have a chilling effect on getting qualified candidates, and whether or not it violates the ordinance shouldn't prevent us from not using it. So I would disagree on that minor point that we have to be the perfect example of what you can get away with rather than perfect example of what we'd like to see.
Is that a hand, Pete?
And just to be real careful about what Carol pointed out, you can, according to this rule, publish at any time, whether upon extension of conditional offer, the employer intends to run the background check. That does not include saying you must pass, for whatever that might mean, a background check. The other thing that I think it's worth pointing out to folks as you read through the guidance to employers is the comparison that's made with the Americans with Disabilities Act, because you can't discriminate on the basis of a disability. And I think we all agree that you can't in a job advertisement say, you can't apply for this job if you have a disability, or we're going to do a disability check on you. And there's a whole discussion in the beginning of this document about figuring out what the essentials and marginals, which is the language used when you're doing a disability check, would be like when you do a criminal background check. That you actually would have to list out what kinds of convictions and what kinds of risks you're trying to, alleviate. So it's what's written is really pretty subtle and pretty carefully worded. And I think it's why, speaking as an individual who was on the commission at that time, I think that's why I was okay with the way that Todd had proposed to go forward with this. It actually does carefully go through this little dance you have to do. And all that said, of course, without concluding what an application should or shouldn't look like, I do like Bill's idea that the city should probably be the shining example of how to do an application for other employers.
Is there any council member who hasn't weighed in yet who wanted to speak? Okay. Fran and then Jared.
Yeah. Oh, sorry. I just had a question for Carol. The guidelines, there was kind of a scramble to get a copy of these because I wanted to provide it to the commission. I mean, to the council. But you say you do use it and show it to employers. And I was wondering if it's anywhere on the city website or what copy you use. I would certainly like to see that. And so we're on the same page, literally.
No, it's my understanding. Go ahead, Elizabeth.
Jessica, it's my understanding that it's never been put on the city website, but I believe in 2013 or 2014, there was a mailing and it was distributed to employers, but you're right, it probably should be on the website, a more cleaned up version. I don't know why it's never been there.
And my understanding is that it was the basis for a series of educational, workshops or briefings for employers in the past.
I just thought maybe you had personally used it, and I was okay.
I actually went out on some of those briefings.
Yes, he did. Yeah.
They were sometimes amusing.
Jared, you had a comment?
Yeah, I don't know, Carol, if you got what I had just sent you a minute ago, but I just sent you an email that is the language at the bottom of that statute. Well, not at the bottom, but the bottom of that first section under section 15 under C, where it says, and this kind of, I think, clarifies where we're going with this a little bit. This section does not prohibit an employer from notifying applicants in writing, I guess that could be interpreted whatever way that you want, of the specific offenses that will disqualify an applicant from employment in a particular position due to federal or state law or the employer's policy. So in my mind, that kind of gets to the core of it, where, I think right now we're blanketing the language too broadly and, just generally saying what we're saying in the application process, in the job posting. And I don't, while, I think the criminal justice system and going beyond it to continue punishing people, there's an argument to be made there that's very, very strong. And of course, this is going to be an extraordinarily rare situation that you're going to have somebody who's been convicted of identity theft applying for an IT position, I guess, unless they've stolen someone's identity to do it. And that's why we're doing the background check. I don't know, but I feel like this is an extraordinary situation we're talking about. And the more we make it clear that it's only in an extraordinary situation that, you may have, something in your background that is going to be considered in a job application, that's the kind of language that should be out there. And doing something like using that section C to outline, hey, you're applying for an IT position, here are specific things that if they're in your criminal background check are going to disqualify you from this position. The city, we as the employer or employers within the city are not going to consider anything that is not these particular things in consideration of this job, so that it's very clear to an applicant that that's what it is. I mean, I think that's maybe where the sweet spot in between the don't say anything about it at all and don't be too broad in how we're portraying it might find resolution for this.
Eric.
So speaking to Jared's comment there, I think the problem with being very, very specific and saying only for X, Y, and Z is that you may not have thought of the whole set of possible things ahead of time that you might come across that would give you good reason to pause and say, hey, this is a nexus, this is a problem. And I worry a little bit about, you said, oh, maybe, someone who's convicted of identity theft wouldn't apply for an IT position. I don't think you want to be encouraging Urbana as a place where people who have propensity to commit a certain crime perhaps would apply to Urbana because they know they could find a place to do it here. So you have to balance the risks both ways.
But now you're talking about discriminating against people for criminal backgrounds. Like you literally just spelled out discriminating against somebody for a criminal background thing. Like that could be completely irrelevant. And that's what we're talking about.
Mary Alice, and then Fran.
So just to understand what Jared's point was, and since we've been talking about throughout the HR process, is Jared, are you saying that once, for example, if you want to interview somebody, you can send a letter and say, we really want to interview you for this position and so forth. Just so you know, this position does require you to have access to personal identifying information, and therefore, in some instances, a background check might cause for further discussion or some kind of like little narrative there that talks about how the job duties could potentially interact with some kind of conviction, but that would only be done at like the interview process. It wouldn't be done at the actual job ad. That's what I'm just trying to figure out, where would that be in that process?
Yeah, and I think that's what the state statute kind of makes pretty clear. I'm not even talking about our ordinance because I think our ordinance is even more restrictive than any of this. So I'm trying to keep it to the baseline level that I think even applies, and I think that's the state statute, which is my reading, my interpretation, where in that part where it says that not to disclose, then I think that eliminates the application part. But it says if you've been selected for an interview or conditional offer has been made, then that would come up. That's where that disclosure happens that that I'm describing. And Eric, to your point about this is again I get your point. It's the hypothetical problem of like, well, can we imagine all the hypotheticals that could possibly eliminate somebody from a job, and do we have to spell out every single one of those hypotheticals? No, I don't think that's what I'm getting at. But we can be more specific than just the general description of must pass a criminal background check in disclosing of that. I know Pete's got a thought about that because I just saw him raise his hand.
I think Fran wanted to weigh in.
Well, a lot of good things have just been said by Mary Alice and Jared. But I'd like to say that you can say in a letter, the kind of letter that Mary Alice suggested, you can say something like looking for things such as, you don't have to have a definitive list. And I agree, I want to emphasize it's very important not to get yourself in a position where you are relying on the presence or absence of a criminal record, a criminal conviction, as some kind of indicator of moral rectitude, because it isn't either necessary or sufficient and should not be used in that way. And that's what all of this legislation is about. And I think it's pretty clear that we should be very, very cautious in how we use it. So we start thinking of it in the same way we think about other protected classes. because it's just like them. That's all I have to say. Thanks.
Pete, you're
Yeah, to respond to Eric, and this was a conversation we had with employers at the time. The situation you laid out, the hypothetical you laid out, is we've gone and looked at this person's resume and it's great. And we've gotten their letters of recommendation and they're fabulous. And the person's job history is unblemished. And yet they have this criminal conviction, and that's the disqualifying characteristic. And the answer is never happens, because you're going to check, all sorts of things. And if the criminal conviction is literally the only thing on their record that is the problem, and yet they have all of these glowing recommendations, A, you probably should offer them the job and they should probably get it. And B, they're going to be in front of the commission anyway saying, I was perfect. They clearly discriminated on the basis of the criminal background check and therefore are violating the law. So I mean, we had to explain this multiple times to employers, but really this situation doesn't come up.
Sharice.
I've been listening to everybody trying to digest all of this. I guess what I would like to know is that, can it be simply dealt with regarding how we determine a person's criminal background? I don't even like using the word criminal, but let's just because it could be something as small as shoplifting or whatever. But let's just say, by just saying, application may require, and not will require, but may require that that we checked for a criminal record, or just changing the words regarding this position, not what you're not, if you got popped for something when you were 16 and you're 36 and you're applying for a particular position, and that thing that you got popped for has nothing to do with the position that you are applying for, wouldn't it just be just the language that is used, could that ameliorate the situation as far as being between that rock and a hard place? Because that's what it seems. I'm not, I know I've had to go through background checks and so on and so forth. So having not having a record, and not having, been too scared. I'm more scared of my mother than I was of the police. So, not having that kind of experience, that rebel without a cause period in my life, I wasn't worried about it. But there, and that's not, and I'm not trying to say I'm perfect. I don't expect perfection from anybody. But maybe just changing the language to say may instead of will, or, this particular job may, for your information, we may require at the end of the interview, before offer of employment or something like that. Would that change anything? Anybody?
Jared.
Yeah, Sharice, and I think you're exactly right that that language is extraordinarily important, and that's one of the things I was trying to get across with the must. And Pete's been trying to get across with the must pass language, and needing to use something, and it could be as simple as, like in the slideshow, we have that list of city practices where it says background checks are required only when there is a statutory requirement and a significant nexus with the essential functions of the job. Even that I feel like strong, but even saying that, when you get to that portion of, the job is, I think it's important to post it on the city website, like in straight plain language, and as expansively as possible, how background checks are only considered in the context of the entire application, in the whole, picture of a candidate. They will never be used as a discriminatory factor in hiring. They will, only be used according to these practices, which have been approved,
But see,
by our
even using-
HRC and so on and so forth.
Yeah, but even using the word only, it to me, it puts you in a box, not necessarily have absolute language, but have gray area language, I guess, because a person that has been convicted or found, I mean, unless you are looking for that for a position to be filled to keep other people from stealing your identity or something, you're not necessarily going to hire a person who does that for or did that in the past. But I'm just saying it is, maybe this should be more gray area language. It is possible that, or it is a probability that that we will be looking just, and maybe that could solve even what we're talking about, because it seems to me in listening to everybody's like we're constantly between that rock and a hard place of when do we protect, how do we protect our how do employers and protect what they're trying to do, and without actually discriminating against somebody who may, you don't know the character of a person when you're interviewing them. You don't know what they're capable of. And that's just been obvious for, the past 4 years with a person that was sitting in the White House. So and we didn't get to interview him. but it's one of those things where you just don't know how far some people will go. So or what they may be hiding. And I do think it's important that they have knowledge that this could possibly happen, but I don't know that is something that has to be so absolute as you must pass. You understand what I'm saying, Jared?
Yeah, I get you.
Okay.
I'll wait for other comments.
Well, I'd like to summarize what we've heard so far. This isn't an action item tonight, but this has been a really good discussion. So what I've heard so far tonight, and please tell me if I didn't hear correctly. Number one, people agree that it's very important for the city to be transparent about the practices that it follows. That's what this discussion is about. So that's what we need to focus on. And that includes the policy, the ordinance, any state, if there's other laws that apply. But state up front what underlies our policy. We need to be very consistent with our processes in hiring, whether it's, it doesn't matter what the position is, but we need to follow a consistent process. And we do. I mean, I've been involved now in enough hiring within the city, and we do have a very consistent process. But the question is also, at what point in the process do we talk about the possibility of us running a background check on the individual? It could happen, currently happens at the point of both the job description and the job advertisement. I'm hearing that people do have concerns about it being in the job advertisement as currently stated, which I believe refers to the need to pass a background check. That language could be modified and better explained if we leave it in the job ad, or could be taken out altogether, but at some point and consistently, we need to be notifying applicants of the possibility of them experiencing a background check. I think we need to, if the state, it'd be interesting to know what the state statute actually requires of the city and whether or not there's a home rule exemption. I don't think anybody's actually determined that or not yet, but we need to know what the state law is saying. And we could put more information on the city's website. Anything else? Jared?
I think the other one that I might suggest is the consideration of removing the button that must be selected consenting or acknowledging the criminal background thing in the online application as well. Disclosure wherever it's happening, probably, you know, if we're gonna do it in the application process still or whatever, should just be a disclosure. I don't know that it should require a checkbox to be checked in order to complete the application.
Which button are you talking about?
It's let's see.
I don't think the city, does the city, are you talking about the library application?
Well, from what I understand, is there a different application portal for city applications? Because it says the City of Urbana and Urbana Free Library employment application.
Elizabeth can answer that.
So just to clarify, they share our portal, like we share many things, like our financial system, but we don't create their job postings, they do. So they may be different, correct?
Well, okay, well, I mean, regardless, if it does exist in ours, we should figure out if it does. And I believe it's under the under section 5, under the job questions. So it should say job ID, the job number, and then questions. Right now, it's question 7, due to sensitive and confidential nature information encountered. Of course, where a candidate must satisfactory, I agree and understand, must be checked in that. At least that's when the one that was given to us. So I don't know if it's in the city's one too. It looks like it would be in both, but if it's there, I'm just arguing that it should be a disclosure. Sure, if we're deciding that it should be there, but it shouldn't be a button you have to click to complete it. That's the only other one, but I think you got everything else that we've discussed that we need to like make some final determinations on, Dan.
Anyone else want to weigh in? Fran?
This isn't a correction to anything you wrote. I just feel compelled to say that I think the city should be very careful about seeking a home rule exemption to the state law. I think it should follow the state law, particularly Urbana, which prides itself in being enlightened and progressive, should not have a home rule exemption that makes it do the more regressive, less enlightened thing. That's just my editorial comment.
Understood. I just like to know what the law actually says. So.
Oh, of course. Well, yes, of course.
Place to start. Any other comments?
It's a pretty short statute. It's only like 3 paragraphs. It'll take you one scroll on a page to read through it, and I didn't see any home rule language in it when I read it. But I don't know, maybe there's a reference in there that I'm missing.
Still working my way through the American Rescue Act, which is 700 pages plus. So.
Well, that one will make for light reading then.
Okie doke. All right. Well, this is a lot to digest. We'll go back and consider these things and come back. Thank you for the input. Thank you, Fran and Pete. We apologize for bumping you multiple times, but I think this was worth the discussion. Appreciate it very much. And the correspondence from the HRC, I hope to respond to either tomorrow or the next day. So be watching for that. And that will be related to an update on the search for the Human Rights and Equity Officer, which I'll also share with City Council when the letter's finished. So, okay, let me go back to my agenda, which I think we've reached the end of this discussion, and with no further business before this meeting, we'll stand adjourned. Thank you very much.
Good night.
Night.
Mhm.